The ongoing legal battle between Ripple and the U.S. Securities and Exchange Commission (SEC) has taken a new turn. The SEC has opposed Ripple's attempt to seal and redact certain evidence related to the dispute over remedies. According to the SEC, Ripple has not provided sufficient justification to overcome the presumption that these filings should be public. The U.S. Securities and Exchange Commission (SEC) has recently opposed Ripple's attempt to seal and redact evidence in their ongoing legal dispute. The SEC argues that Ripple has not provided adequate reasons to justify keeping these documents from the public eye. This development is significant as it highlights the SEC's stance on transparency in legal proceedings, especially those involving financial and securities information. Ripple has pointed to the SEC's previous sealing and redaction positions, arguing that similar considerations should apply to their case. However, the SEC contends that these earlier positions were context-specific and do not apply broadly. The agency emphasizes that Ripple has been adjudicated to have illegally sold investment contracts to institutional buyers without necessary disclosures, making the current filings particularly relevant to the public interest. You are welcome to Crypto World Educate. If you are coming across this channel for the first time, kindly assist us in reaching a greater audience by hitting the subscribe and like buttons. This will enable us to reach a greater audience. The SEC's insistence on transparency is rooted in the belief that public access to these documents is crucial for general deterrence. The agency argues that hiding financial and securities sales information undermines the ability of the public to understand the remedies requested and ordered. This transparency is seen as essential for maintaining trust in the regulatory process and ensuring that similar violations are deterred in the future. Ripple has argued that disclosing the requested documents could harm its business interests. The company is concerned that revealing specific financial figures or terms of contracts could give competitors an unfair advantage. However, the SEC maintains that the information they seek to disclose is limited and directly relevant to the court's determination. They argue that the public's right to know outweighs Ripple's concerns about competitive harm. The ongoing legal battle between Ripple and the SEC continues to evolve, with the latest developments highlighting the tension between transparency and business confidentiality. The SEC's opposition to Ripple's sealing and redaction requests underscores the importance of public access to legal documents, especially in cases involving significant financial and securities issues. As the case progresses, the outcomes will likely have far-reaching implications for both Ripple and the broader cryptocurrency industry. Ripple's legal team remains confident as the XRP lawsuit progresses, arguing that the SEC's claims lack substantial evidence. Ripple Labs has been steadfast in its defense against the SEC's allegations that XRP, its native cryptocurrency, is an unregistered security. The company's legal team has argued that the SEC's regulatory approach is inconsistent and lacks clarity. This argument has resonated with many in the crypto industry who have long called for more precise guidelines from regulatory bodies. One of the primary points of contention in the lawsuit is the SEC's inconsistent stance on what constitutes a security. Ripple's legal team has highlighted that the SEC has not provided a clear framework for determining whether a digital asset is a security. This lack of clarity has led to confusion and uncertainty in the market, with Ripple arguing that XRP should not be classified as a security under existing laws. Legal experts and industry analysts have noted that the outcome of this case could set a significant precedent for future regulatory actions in the crypto space. The ongoing lawsuit has had a noticeable impact on the market, with XRP experiencing significant price fluctuations in response to developments in the case. Investors and traders are closely monitoring the proceedings, as the outcome could have far-reaching implications for the broader cryptocurrency market. A favorable ruling for Ripple could bolster confidence in the crypto industry and potentially lead to more favorable regulatory conditions. Ripple has garnered substantial support from various industry stakeholders, including other cryptocurrency companies, legal experts, and advocacy groups. Many believe that a victory for Ripple would be a step towards more rational and fair regulation of digital assets. This support underscores the broader sentiment within the crypto community that clearer and more consistent regulatory guidelines are needed to foster innovation and growth in the sector. As the Ripple versus SEC lawsuit progresses, the outcome remains uncertain. However, Ripple's confident stance and the growing support from the industry suggest that the SEC's case may not be as strong as initially perceived. The resolution of this legal battle will likely have significant implications for the future of cryptocurrency regulation in the United States, potentially paving the way for a more defined and supportive regulatory environment. Let's reveal the latest developments in the SEC's stance on spot Ethereum ETF approvals and what it means for the future of crypto regulation. The odds of approval for spot Ethereum ETF products at the start of this month stood around 25%, according to a Bloomberg analyst. The scenario changed a few days ago when the odds jumped to 75%. In his analysis, John Deaton said when the SEC's regulatory war over the past 4 years is merged with Senator Elizabeth Warren's anti-crypto stance, this push to approve spot Ethereum ETF is the biggest turnaround possible. The crypto lawyer recanted the role he has played over the past years to bring the results today. When SEC Chairman Gary Gensler started his tenure, He inherited the Ripple lawsuit from his predecessor, Jay Clayton. It was in this case that John Deaton showcased his deep interest by representing XRP holders. His representation saw Judge Annalisa Torres declare in her ruling last year that XRP is not in itself an investment contract. On this subject of investment contracts, the regulator placed Ethereum in the spotlight as a defaulting token. While it is yet to officially declare the cryptocurrency an investment contract, chatters within the regulatory body suggested that might be the reason for the spot Ethereum ETF denial. The market rather saw a turnaround with clarity regarding Ethereum classification still obscure. The current shift, as marked by communications with stakeholders vying for ETH ETF in the ecosystem, is attributable to a political shift. Many crypto industry leaders believe the regulatory landscape in the United States is now largely political. To join the fight beyond the courtrooms, John Deaton is contesting the election to displace Senator Elizabeth Warren. While he has bagged the support of many crypto industry leaders, John Deaton has always expressed confidence in his ability to bring change should he get into politics. Pending then, the industry has a lot of evolution to court, including adjusting to the reality of spot Ethereum ETF trading on national exchanges. The unexpected shift in the SEC's stance on spot Ethereum ETF approvals marks a significant development in the crypto regulatory landscape. With John Deaton's continued advocacy and potential political involvement, the future of crypto regulation in the U.S. remains dynamic and closely watched by industry stakeholders. Please note that we are not a financial advisor. Kindly do your research before making any financial decision.